Hello, everyone. This is Stephen Long, the notorious BIC and broker in charge Kelvin Realty in Winston-Salem. Just wanted to go over with you the new exclusive right to sell listing agreement as a part of this week's BIC tips. I have been trying to review in video format a couple of new pertinent forms. Yesterday was the buyer agency agreement. Today is the exclusive right to sell listing agreement. So without any further ado, let's be as precise and brief with this as possible. Full disclosure, this is not and a very detailed overview. This is meant to cover the changes and go over how to fill this out properly. There is an additional document called the guidelines to how to fill out the exclusive right to sell listing agreement, as you can see noted here. And I do encourage you to review that if you've never done one. If you've done these before, this should be a review. I do want to cover some important topics that are in this form. So hopefully you can follow along and this will be helpful. So without any further ado, here we go. On page 1, we're looking at the exclusive right to sell listing agreement, and it will be entered into between the sellers. And make sure you get all the sellers, whether it be a legal entity, married couple, individual, whatever needs to be put there. Make sure you get all the sellers named. And with the firm, of course, this would be your firm. In my case, it's Keller Realty Elite. And of course, many of you know I also own and operate the Carolina Crew Inc. So both of our firms have to be named in that line because both firms are listing it. A couple of things to remember. Anytime you see a box on these forms, it's very important to go over. This particular box goes over the fact that if this is an estate, meaning the seller recently died, basically to do your due diligence to contact an attorney, make sure that the persons you have signing this form have the legal authority to sell it on behalf of that estate, and whether or not there is or is not a will. So check those boxes out and do your homework in that regard. Let's start with paragraph 1. And on this also says you've gone over the work on a real estate agent's disclosure, which you should have always done prior to this point in time, but we'll go over that another day. Paragraph 1 says term of the agreement. This is basically a start and end date. Every agency agreement has to have one, a start and end date. So if we're going to check the first box, that means it would be the effective date is the day that it is signed by both the seller and the firm. If we're not quite ready to put it on the market today, we can choose another line here in a minute to make it in the future. So we're going to go ahead and list it now, and then it could be that we're going to have a marketing date in the future, and that's often confused. So the date that we're actually getting this listing agreement is the date that both parties sign it, meaning it is listed with our firm exclusively. Marketing is yet to be seen. We're going to come back to that in just a minute. It could be marketed now, or it could be marketed in the future, but right now it's listed, meaning I'm the only firm that it could be listed with. Now, it could be possible that you are on a listing appointment with a seller that is currently listed with someone else, and they're not happy and they want to hire you in the future. And so you would check this box and denote when their listing agreement would expire, and then that becomes the effective date of this agreement. And as I told you, it has to have a start, and this would be the end date. So you have to have an end date in which the listing will expire. On paragraph 2, the property is going to be described in the best of your ability to give the most detailed description as possible. Obviously, the address, legal description is very important to try to make sure you're describing everything that's being sold in totality, whether it be one parcel, two parcels, a parcel, a mobile home, whatever it is. Don't be afraid to use this other description. The house at 4.5 acres located at 123 Main Street, and near the corner of Main and Oak Street, whatever you want to put there. Just be as descriptive as possible so that no one can ever be confused about what you were selling or what you were hired to sell. Again, you got a couple more boxes. Paragraph 3 and 4, the proceeding are actually out of the offer to purchase and contract, but they're in the listing agreement here to prepare them for that, which goes over fixtures and personal property. So again, fixtures are anything that are attached, fixed, glued, screwed, in any way bolted to the property that when removed will cause damage. And so it does go on to talk about fixtures, and that all fixtures are included in the sales price, and it even lists some out. A couple of most notables is it does say all bathroom mirrors, because in some cases people like to take their bathroom mirrors, things like thermostats in the world where we have smart thermostats. So we want to make sure that we are in fact taking care of that conversation very diligently. So take your time and slow down and go over those with your client. Likewise, any smart devices need to be unpaired. So if they have security cameras, smart thermostats, smart appliances, any of those things need to be unpaired prior to the transaction or the close. Now, it also goes over things that may or may not convey. So items leased or not owned are things that the seller doesn't own. So they can't sell what they don't own, but then the new owner would have to be responsible, or the buyer would have to be responsible as to whether they wanted to pick that up, including things like satellite dishes, antennas, any kind of receivers, appliances, alarms, or security systems. There may be other items that do not convey. These would be the items that are fixtures that the seller intends to remove. My best advice is to have all fixtures removed before you put it on the market, so there's never any ambiguity in that regard. But in the event there is a chandelier, as it always seems to be, that the seller wants to take with them, that would be named here, meaning it would not convey. Make sure you get it not only here, but in the MLS, and most importantly, on the offer to purchase and contract, because it has to be on the contract to be enforceable. Again, the seller is going to be responsible for any damage for anything that they remove and have to fix that back as well. Under paragraph 4, we're going to talk about that personal property. Those are things that personal property that the seller shall leave at the time of closing, basically anything that they're willing to transfer with the property at no value. Sometimes it's a refrigerator, it could be a couch, it could be a number of different things. This particular box says consult with your lender, because lenders do not want to see a lot of personal property on a real estate offer to purchase. So you'll see that there. Under paragraph 5, we talk about a home warranty as to whether the homeowner is agreeable to have a home warranty in place now, and if so, what cost? And likewise, if the firm or the agent is getting a marketing fee, what would that be? So we can cover all those in paragraph 5. In paragraph 6, most importantly, we're looking at the listing price. Now you can include your listing price here in paragraph 6 is what the seller wants to list it at. And then you can choose the types of financing that the seller is willing to accept, and you would fill those in here. Under paragraph 7, we're looking at the firm's compensation. The firm's compensation is what the firm is getting paid in total to pay the entire commission or get paid to sell the property. So for example, if it is, and these are of course round numbers, this is not a discussion of commission or setting commissions. So for example, it is a 6% commission just for round numbers, and you intend to pay 3% to a cooperating firm, which we'll get to in a minute. And then 3% plus 3% is 6%. So the firm would get a total of 6% here. And then you would, of course, dictate how much of that you're going to share down here in just a minute. Now, on this next line where it says, or it may be a flat fee, we get hung up on percentages. Sometimes it might be a flat fee, and you can input that there as well. So if sometimes people charge a retainer fee or otherwise, you would want to dictate that and disclose any compensation you're getting in regards to the transaction as well. Now, the next section goes over some of the when the fee is earned and some things with a protection period, just like we did in the buyer agency agreement. If you provided the seller a list of clients prior to the expiration of your, or within 15 days of the expiration of your listing agreement, and any one of those clients then buys the house, you would potentially have been deemed earned to receive your commission. You do have to put in whatever period of time, whether that's 30, 60 days, whatever your protection period is. As a reminder, this paragraph and the protection period is null and void if they relist with another firm. So if they enter into a new listing agreement, none of that matters. That's just to really keep them from skirting you and going straight to the buyer and cutting out the agents. A couple of things in there about that to read. Also, if you're getting additional compensation, you would disclose that. There's a form 770 that would help you do that to disclose it to your client. Now, paragraph 8 shows of that total commission that we're collecting, how much of that are we going to share with other brokers? Now, we might cooperate with subagents of the seller, meaning these are people still working for the seller, not representing the buyer, and how much of that commission will we share with them? And then we also have the option to cooperate with buyer's agents, meaning they are working for the buyer, and what amount of money we would agree to share with them. So if you're going to provide both of those, you would fill in both of those percentages. If you only want to work with buyer's agents, you would put that in as well. If you have a written policy for your firm, you can just check that box and attach it, and then you don't have to do either of those. Most of us would probably choose one or two, but you are welcome to choose any of the three. Now, paragraph 9, the firm's duties are basically things that you should already know, but of course, we're going to go over the boxes because the Code of Ethics does cover some things that we have to do as realtors that maybe an individual or licensed agent may not have to do, including making sure that we are not soliciting the other firms' listings and abiding by a code in that regard. Best efforts to find the buyer, disclose material facts, discover and disclose. We're, again, real estate brokers, not anything else. Make sure you read through these paragraphs. We're going to provide an agreement to listing service and make sure we get an NMLS. On the next page, you're going to see the bold, capital, non-discriminatory language. Just below that is the red box that says, talks about love letters or letters from the buyer to the seller and how they can, in fact, implicate both the seller and potentially the listing agent. in regards to violation of fair housing laws. So that's why we have them initial right here stating that they have gone over that. And you should have a conversation at the time of taking this listing on how you and the seller would like to handle those love letters. They can be definitely quite dangerous, so be careful on how you want to do that. My advice is to avoid them, and you can initial there on what you agree upon. Paragraph 10, we're going to talk about marketing and commencement of marketing. Now, I told you on page 1, we have a list date. That's the date that they agreed to list with me. On paragraph 10, we're looking at what point in time am I allowed to tell people that it's listed? Marketing, meaning sharing it with other people about the house being for sale. So commencement of marketing, it may be that we sign this listing agreement today and you've got some painting and touch up and things that you want to do to get it ready. So you're not going to be ready to go be marketed until next week. So we might have a marketing date a week from today. Now, remember, that also says here that while we're from the time we have it listed, the day we sign this to the time that we go marketing, I'm still responsible for presenting all offers to the seller. So if the neighbor finds out we're going to list it and that neighbor wants to make an offer, I'm still obligated to present it to the seller. And then this box basically states to the seller that you may want to consider putting it on the market, just because when it's fully exposed, you have the potential to get higher amount of money. It may not be in your best interest to take one without it being fully marketed. So now they have to choose in this next section, either public marketing or an office exclusive, but not both. Most cases and in most situations, public marketing is going to be the best option for the client. So you're going to check public marketing there and they can initial. And then you're going to let them initial and check the items that they want you to do. So coming soon, signs, open houses, advertising, internet advertising. And if you're going to do a coming soon, typically that's going to come with a coming soon addendum. Now, the 3 dates that get confused are the date on the listing agreement, the date we took this, right? The effective date of this listing agreement, the marketing date, and the coming soon advertising. So if you're going to do the coming soon advertising, please read the coming soon addendum as prescribed by your local association. You will have to provide that. But the coming soon is when you start marketing coming soon, it is also marketing. So it needs to the marketing date and your coming soon date need to correspond with each other. Now there's one more date here that is active date, and that's the date that we go from coming soon status to active for showings. Coming soon is still being marketed as coming soon, so it still corresponds with your marketing date, but the active date is the date at which it actually becomes available for showing. So it's coming soon, no show until this date. So you can put that date in there. Those are often confused dates. Hopefully that's helpful. It does, on the next box, it does talk about Form 105, which may be used to limit internet advertising in the event that the seller wants to try to limit that, which is very difficult and often not effective. Office exclusive, if they choose that, means there is no marketing outside of the firm and its clients. So this is usually not in the best interest of the seller, but there are opportunities where it is. And so if you're going to do an office exclusive, they need to initial here, basically giving consent to not market it, put it in MLS, or tell anybody outside of our firm that this property is for sale. If that is their goal, then that's what you'll choose. Now, note inside the box, listing agent must submit the listing service and disseminated participants with 1 business day of public marketing. So again, once we have that public marketing date filled in, we have to put it in MLS within one business day so that it goes out and is in compliance with the clear cooperation from NAR. So if they're not going to do if they're going to do public marketing, then you have to have an MLS within 1 business day of marketing. If it is office exclusive, it will not go in MLS. So that is a very important distinguishing conversation to have. They are hopefully going to authorize you to put a lot box on my property so that folks can access it. And there's a couple of acknowledgments, basically, that there's a lot of things that go on in conjunction with marketing the house. And at the short end, the seller is agreeing to hold us harmless for any damages or issues that may come out of those processes, less any negligence. So if you're negligent, you're still going to be liable. But if we're not negligent, there are sometimes things that happen. And in fact, like the seller should be responsible for getting their cash, jewelry, firearms, and anything else put away so that it can't be picked up or walked off with. Now, this is also an important box. Make sure you tell your seller it is a crime under federal law to record any oral communication without consent. They can, of course, have their video cameras up on their house to have video surveillance. It is their right to protect their property. However, if they are listening in on conversations, they will need that consent from those persons before doing so. Otherwise, they may be in violation of federal and state laws. So do not let them eavesdrop on the buyer's conversations and have that discussion. On paragraph 11, we're talking about earnest money, which either your firm does or does not. In most cases, our firms do not these days. If you do, of course, you want to make sure you disclose that and share where the earnest money is being held. Typically, it's going to go to an attorney, in which case they will be there. And if there's any dispute, it will be released to the clerk of court. So paragraph 12 says the seller representations. This is where the seller has to give us some disclosures of how long they've owned it for less than a year, more than a year, or does not yet own the property. In some cases, they might be selling a future interest. It could be in a state where it has not yet been properly transferred. So there's a few instances where that may arise. And it does say if they do not yet own the property, they will need to make sure that they provide us information about that as soon as possible so that we can get that sold without any hiccups. On paragraph B, whether or not they're contemplating now or in the future having declared bankruptcy. If there's any issue with access to the property, if we don't have proper easements or right of ways, this is an important disclosure here because we cannot really sell landlocked properties. We want to make sure that we have proper access to it. If you're selling a mobile home, there's a whole nother bag of tricks there, but there should be a VIN number on it as to whether if it is in fact a mobile. Maybe a modular would not have that VIN number and not fall into this, but a mobile home will have a VIN number, and you would need that here, and also do your homework as to whether that has been relinquished as a part of the real property, or if it's just personal property being conveyed at no value with the land. If there's an owner's association, how do we contact the managing company or the HOA? And if they have a website and contact information, fill it in there. If the paragraph F, you need to check these two boxes and make sure that the seller gets sample copies of the offer to purchase the contract, and make sure they also get the sample of professional services disclosure election form. Under the following, we have a few disclosures for the seller to fill out, including whether or not they have flood insurance. This does not indicate whether it is or is not in a flood zone. So if you'll notice now, it is or is not located. This is the seller's disclosure. This is not the broker's reliable representation. You should still check ncfloodmaps.com to verify their disclosure. This is just a disclosure. Don't let them go awry and misrepresent it. Double check behind them. They may or may not can maintain flood insurance. If their house is paid for, their lender may not require flood insurance. Therefore, they could be in a flood zone and not have flood insurance. So please always check NC Flood Maps if you have any indication that there might be a flood zone in the area. Synthetic stucco, as to whether they have any or whether they've ever known of any issues with that. That is the exterior insulating and finishing system. It's basically a synthetic stucco type of product. If you see stucco in the house, ask questions. Is there or is not a termite bond? A termite bond is not the same thing as a termite treatment. Termite bond is they've had it inspected or addressed, and they will in fact have a bond that says if termites ever show up, the company will come out and treat it for free. It has to be renewed typically every year. So that's not a quarterly pest treatment. That's not an annual treatment. That is a bond. So that's a totally separate item. Current liens are things that you need to know about to make sure that when we're listing the property, we have the right, we have enough money to not have an upside down seller or be in a situation with a short sale. So kind of fill out their lender name and approximate balances. Does not have to be precise. We just want to make sure that we can do a net sheet and then we have information. This is also helpful for an attorney if they're getting ready to do their title search so that they can reach out to those lenders. It also talks about whether or not they're current or defaulting. So make sure you ask those questions and go over these paragraphs about any judgments or anything else that might prevent them from selling the property or create any kind of lien against the property. Tax liens, judgments, etc. If there's any leases on the property, it may or may not be subject to those. You would check that here, and also go over the fact that if there is a lease, what does the property manager's name and information look like so that we can get with them. And this is giving authorization for that manager to cooperate with the listing firm to get them the information necessary to sell the property. If there has been an FHA appraisal on the property in the last 4 months or 120 days, the seller has to choose one of these, has or has not been done. If one has been done, then of course we need to procure a copy of that because that FHA appraisal will stick to that property for 120 days. So ask good questions. Any special assessments, sometimes there might be a special assessment by a city or an HOA for a sidewalk or for a deck rebuild or for roof replacements in a townhouse or condo community. So we want to ask about any of those that might be outstanding. As you recall, any confirmed assessments are going to be the responsibility of the seller. Any proposed or pending assessments will be the responsibility of the buyer until they are confirmed. And this is a new change. We're talking about fuel tanks. So in the event there are any fuel tanks, take note, fill it out appropriately as to whether there is one, whether it's leased, whether it's owned, whether it's in ground, below ground. Also make sure you're asking about any underground or potential underground oil tanks and the issues that surround that. That's a whole other topic as to whether there is one. If it's on a refilling schedule, excuse me. Lots of questions to ask if there's any fuel tanks. Now, interesting enough, a new addition to this is in regards to the fuel. So it does say that any fuel in the tank is the seller's and will be used up until the time of the sale. They cannot sell it back to the fuel company. They can only have it in the tank. They can use it. And then once it's sold, the new buyer basically assumes whatever's in that tank. So the seller does not get to remove the fuel tank. We're not selling it or prorating it. Whatever's in the tank as a seller to use until we close, and then whatever's in the tank is the now buyers to use and they see fit. So that's very clear cut description now. It is advisable for the seller to reach out to their fuel tank providers and make sure that they are in compliance and make sure they're not going to be violating any terms of their use with the tank in conjunction with the sale. And also it can facilitate the utility hookup for the next owner. So have them make those conversations earlier rather than at the last moment. The seller does have a lot of duties, as you know, and you should read through these. Basically, they have to provide the disclosures as required by law, make sure they fill out, be honest with you, any owners association, keep you current, make sure that they give you any information. And then at the end of the day, they have to be able to provide a general warranty deed in conjunction with the sale. And if none of those things can happen, we need to address the exceptions below. So if none of their duties can happen, they would list those here. Hopefully they all should be able to, and we can put in a if the property is a short sale, but also use the short sale addendum, that's form 104, and that is a whole nother class. So if you can run into a short sale, seek help with those. If there's a home inspection, or if the seller has had a home inspection, that's wonderful. That helps address a lot of issues. If there has been a home inspection in the past, ask those questions if they are recent. Sometimes the seller may opt to get a home inspection voluntarily before or at the time of going on the market. If so, they do or do not agree to do that, and how many days it is going to take for them to get said home inspection. So if the seller wants to get a home inspection at their own cost for discovery purposes, that's where you would address that conversation. Paragraph 15 talks about photographs and materials, and essentially they're proprietary, and that some folks will in fact probably try to take pictures, and you cannot prevent them from using them for their personal use, but just make sure, and as I tell people, everything in your house needs to be taken down that has any personal or confidential information, as these photographs will go all over the world and all over the internet. So if you don't want the world to see it, take it down. So kids' names, degrees, favorite schools, anything you got that might allude to a security question or give insight into your life, I would neutralize the house as much as possible. Paragraph 16 says additional terms and conditions. This is where I often insert my 24-hour easy exit plan, as I did on the buyer agency agreement. It says if at any point in time you're not happy with my service, give me 24 hours to correct the issue. If I cannot, then you're free to fire me and move on without owing me anything. That's just a personal choice. Anyone's welcome to have something different, but that's just what I use that additional terms for. Paragraph 17 says dual agency and goes over the types of agency, which again, it should have already been covered in the work of real estate agents disclosure as to what your firm offers. This is now the opportunity for them to choose of those options. What do they want? And it does go over, of course, dual agency, seller's agency, etc. I'm not going to rehash those types of agency conversations, as you should know them by now and should have already had that conversation under the agency disclosure, where you showed them all the ones that your firm offers. Now this is the form where they choose of all those offerings, which ones do they want. A slight change in how you fill it out is essentially they have to choose one of the two, either dual agency or not. If they're choosing dual agency, then they have the ability to allow you to be the one agent, dual agent, where you are a coach, or they will not allow that, meaning we are not going to let you be the one agent, dual agent coach. Now, if that is also the case, they may also opt for designated dual agency, where in designated dual agency, with the dual, it's the referee. With designated, we have two coaches where they coach each other. If they want you to authorize, do not authorize you as the represent the buyer and seller, that's fine. You can stop there. If they also want to make sure that there are two agents from the same firm and neither of them has any information about the other, so that each can coach their respective clients, then you would choose designated dual agency and defer to your firm on how those policies work and how agents are in fact designated. So they have to choose one of the two. and then they have to check one of these boxes. They have the option of also checking designated dual agency if they so chose. So check here, and possibly designated dual agency if they choose. Now, paragraph 18 goes over the different scenarios as to how we get out of this contract. And it could be a termination, it could be a breach. In the event we have a dispute, we go to mediation. Likewise, if there are attorney's fees involved, then the prevailing party will then, of course, reimburse the non-prevailing party. Under paragraph 19, we have the wire fraud addendum. Just warning folks about wire fraud, especially on the seller side, as they are getting proceeds wired. That could be a fair amount of money that could be lost. So be very diligent in having the wire fraud conversation. On paragraph 20 says we've gone over the entire agreement. There's no hidden deals, no side hustles, nothing under the table, and that there's no additional forms or anything that are not included or referenced from this one. And of course, if you have any questions with that, they should be with agency. There's also things like the Q&A brochures, including the Q&A on working with agents, Q&A on selling your house. There's a lot of brochures that if your client has additional questions, they can get additional materials and education. Then with that being said, everybody signs, make sure you have the proper signatures for all sellers and all parties. And of course, you fill out your information in totality as well. If in the event you have an entity, you would put the firm name there, you would put the entity's name here, like an LLC or corporation, and then who is signing on the behalf. Just if you need additional room, there is an additional provision or additional signatures addendum. So if you need multiple sellers, you can add the additional provision or additional signatures addendum to this as well. And with that being said, that wraps up our listing agreement. So I hope this is helpful. Again, this is a quick overview of the new form, just a very few minor changes. Hopefully that's very helpful to you guys in filling those out. If you have any questions, feel free to let me know. Likewise, reference the guidelines for the exclusive right to sell listing agreement. It's a very helpful document as well. So without any further ado, I hope that's great. And I look forward to covering the offer to purchase with you very soon. Have a great day.